was right about the shoe. The shoe was not the same in the pic shown in court as the shoe pulled from the evidence bag by Trooper Bukake.
You mentioned you're at the hospital. There was a sneaker. One.
Yes.
Bukake!
Woo! Good evening, friends. It is good to see you guys. I hope everyone is doing well and having a wonderful week. Check it out, people. I'm moving into Aiden's spot, bro. Okay? It's totally what I'm doing right now. No, listen, unfortunately, Aiden is not going to be going live tonight, I don't think, because he is suffering from an ear infection. And if anybody's ever had one of those, then you know how painful they can be. But no, I figured I was actually going to go live earlier today, and then I saw that Jimmy was live, and so I was like, you know what, it's better if I just go work out. You know, so I went to the gym. I made a nice meal. I made some chicken breast and some rice and beans. It's good, real good. So yeah. But I have to confess, the truth is that it was all part of my very, very elaborate plot. What do you think I do with this membership money, people? Listen, this is what happened, okay? I had someone break into Turtle Boy Aiden Carney's house, okay? And I had this person, a professional, okay? Professional. I had this person drop infectious material into Aiden's ear as he slept. This was not cheap. And so it's all a part of my elaborate plot to move in on Turtle Boy's spot on YouTube. It's all coming together. It's all coming together. Yes, that's where my membership money goes, folks. That's where your money goes. Is to execute my long game nefarious plot to take over. Because as you can see, I'm packing so many people in here right now. There's a whole whopping 320 people here, and Aiden isn't going live tonight. So I wonder how that's working out for me. But no, man. We're gonna go over now. We are gonna check out now. Listen, there's a new Letterows letter. We're gonna go over it. It's important. I haven't read it yet, but and Paulie G, member for 8 months. I heard BLT has a yeast. That wasn't even that clever, but it was pretty good, man. It was just the simplicity of it. The simplicity of it is what I like. Well done, sir. Well done, Paulie G. Oh man. Yeah, so we're just gonna kick it. I'm gonna open up the phone lines later on. And listen, how we're gonna do this is my man Grant Towel Smith Ellis Grande, if you nasty, okay. He has put some sort of weird voiceover thing over the newest Letterows letter. We're just gonna listen to Grant's post because it's actually pretty dope that he did that. But listen, I need you guys to stop what you're doing right now, okay? And go and give Grande a like on this video for doing it and a sub. Make sure to do that, folks. It's very, very important that you do. I'll wait. All right. Now, there's no time limit on that. The Jeopardy music is just to give you a window before I actually start going over this stuff. Yeah, Grande has dude, that's the thing is like Grande was like almost a supervillain, right? Like it's bizarre, it's weird because like he was almost a supervillain, you know what I mean? And in like the most traditional sense, because like he would never win, you know. He wouldn't. He was doing horrible shit and saying horrible shit, and he wouldn't like, but he wouldn't win, you know. And so, but you could tell that the intelligence was there. You could tell that there is a sense and a desire to be good in there, and Grant just harnessed it. I don't know what happened. I don't know if Gatuni inspired something in him because she's done a big turnaround, it seems too. These are wild times, folks. these are absolutely wild times. And yes, I do. Yes, I'm no medical professional in any way, shape, or form, but I would classify Grant Smith Ellis as a savant. I mean, he's quite brilliant. There is absolutely no doubt about that. And he seems to just be harnessing. There seems to be this place that he's harnessing it from. It is a desire to do really just the right thing and do good things and listen to evidence and focus on what matters and differentiate fantasy from reality. And he's doing great. And I don't mean that in a patronizing manner in any way, shape, or form. The motherfucker finished law school. Okay. I'm definitely not talking about him as if I'm in any way superior to him, because I do not believe that I am. Because we're talking about a guy who just graduated law school, dude. I haven't graduated, dude. I barely graduated high school. I didn't even graduate high school. I got a fucking equivalency. You know what I mean? Like that's so I am in no way, shape, or form talking down about Grant at all. I'm celebrating someone who I've seen just start to apply himself from a different place. And it's just nothing but good results. Fascinating. One of the greatest things that I've gotten to witness in following all this, if I'm being completely honest. So, yeah, big shout out to Grant. Grande, my man. So tomorrow, I'm really excited. You guys may have noticed the drip. I'm really excited because tomorrow, so Rebecca Lavoie of Something's Off, that she does the podcast with Mel Barrett. Both awesome people. I'm big fans of them both. And so Rebecca's husband has a Law and Order SVU podcast with Rebecca, as I believe. And tomorrow, he and I think Rebecca as well, we are going to record an episode of the podcast discussing a particular episode of Law and Order SVU, because I'm a big fan of the show. I have literally seen every single episode. And most of it at this point is like out of principle. You know what I mean? Like at this point, it's just like I've seen so many. Because what happened was like back in like 2010, 2011, between 2010, 2011, I was a concierge at a high-end condo building in downtown Miami. What up, Mazza, homie? Thanks for sending your people over. Yes. And man, I got to say, I am so excited. I am so excited that Mazza is doing select board meetings now. Because, I mean, finally, there's a channel that I want to watch it at. You know, I'm stoked. I'm excited about it. So, going back to it. Oh, yeah, sorry about that. So, of course, but of course, who were you talking to? Obviously you've never watched me cover a trial or a court hearing. So, Netflix had just started streaming, on their site, right? At the time, this is how long ago that was. Think about that for a second. Netflix, it was at one point just DVDs. They mail them to your house, right? You order them. Then later on, you could stream stuff, and there was stuff that was available for streaming and stuff that you couldn't stream yet, but you could get the DVD mailed to your house. But Law and Order SVU at the time was something that you could stream. And I would always catch episodes like reruns on Sundays. You know, whenever I could catch an episode, I'd catch one, but whatever. But then this was a night shift job where I'm sitting at a desk in front of a computer and it's the middle of the night, right? You know, so basically I have to just announce visitors, right? I call the resident and I say, yeah, and then I fob them at the elevator. Um, and so this was they were long nights. And so I watched, they had all of every episode of SVU up to that point on Netflix, and I watched all of them in a matter of like 2 weeks. So this was like 11 years worth, 12 years worth. It was like 12. Yeah, there was 12 seasons. So it was like 12 years worth. It was crazy. And so after that point, I just started following. I was like, I've seen so many of them now. I have to catch every episode. So I started like DVRing the new ones, and then I never missed ever since. So funny thing, little piece of history here. The word fob, the fob, the little thing that you use to open a door that's like a magnetic or whatever, electronic key card, a fob. That got its name from, because the idea is to keep murderers away from you and keep them out of your to lock doors, right? So the word was inspired by the song Psycho Killer from Talking Heads. Fa 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 banner. Run, 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 run away. Right? So fa 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 fa. I'm telling you, look it up. It's a fact. Okay? Look it up. All right, hold on. Let's get into this better letter, people. Should I speed it up? Nah, we got time.
Law Office of Mark A. Letterows, PC, Carnegie Hall Tower, 152 West 57% Street, 8th floor, New York, New York, 10019. August 11th, 2026. William Reynolds, Atlantic County Prosecutor, 4997 Unami Boulevard, Mays Landing, New Jersey, 08330. Rees State versus Aidan Kearney. Indictment number 26-07-1963. C. Dear Mr. Reynolds, I write to request that you voluntarily recuse Chief Assistant Prosecutor Erica Haliko and withdraw the Atlantic County Prosecutor's Office, ACPO, from the prosecution of Aidan Kearney, a Massachusetts independent journalist who has been indicted for allegedly cyber harassing a New Jersey resident he has never met, and even though he has not stepped foot in New Jersey in several years, as the result of an ill-advised August 4th, 2026 telephone call she made to a member of Kearney's legal team to deliver a message to Kearney. Ms. Haliko is laboring under a conflict of interest. In short, Ms. Haliko warned Kearney of her ability to utilize the state's power to conduct criminal investigations to further her own and others' personal interest in having Kearney stop posting her name and the names of others from the ACPO online. Ms. Haliko has strongly implied that the ACPO will investigate Kearney for additional and frivolous charges unless he capitulates to her unwarranted request that he delete any public posts containing her.
Right. So that whole thing right there is basically like, I mean, you can't blackmail somebody with the law, bro. That's not like either you broke the law or you didn't. Like your job as a fucking decent citizen is to turn the person in, or you have the right to fucking shut the fuck up and don't say shit about it and just leave it alone. Right. But you have a duty as a citizen. If you're going to report it, You don't use it as leverage to gain something from someone. And this is totally what happened here.
Name and the names of other members of the ACPO by merging her own and other. A CPO member's personal interest in silencing Kearney under the threat of abusing. Her official state power, Ms. Haleko likely has violated New Jersey rule of professional conduct, RPC 1.7A2.
There's a flaw in the punctuation for the AI voice. There's definitely a flaw in the punctuation, but I'm gathering what I need to. Well done, still, Grande. Well done, my friend.
And she possibly has violated NJSA 2C 138-5A 2 and 4, which is a crime of the 4th degree. Ms. Haleko has another possible conflict looming, which we bring to your attention now. The alleged victim, LS, has made a
which we bring to your attention now.
series of false statements, many of which Ms. Haleko knows are false. Thus, Ms. Haleko Kelly will be a defense witness at trial for the purpose of exposing LS's materially false statements, which creates an additional conflict for Ms. Haleko under the witness advocate rule. See, tell 2128.
Okay, hold on a second there, British Grande. Don't be coming in my chat, Andrea, Kunku lover, and spreading false information, spreading misinformation, okay? All right? That shit is real, okay?
You're lying. And you're a piece of shit.
Okay? Coming in here causing trouble, poisoning my audience's minds. What's wrong with you?
031293. mark@bedrolaw.com. www.bedrolaw.com.
Okay.
Admitted in New York, New Jersey, and Arizona. Law Office of Mark A. Bedrow, PC William Reynolds, August 11th, 2026, of page 2. RPC 3.7. A lawyer shall not act as an advocate at trial in which lawyer is likely a necessary witness. Finally, because Ms. Haleko has implied that she and others from the ACPO are victims of Kearney, by virtue of his publication of a letter containing their names, the ACPO must recuse itself from this matter and allow a non-conflicted prosecutor to assess the merits of the current indictment and other alleged crimes committed by.
I mean, let's get real. That's just crazy. You can't fucking do that shit. Like, how's this lady like gonna negotiate? Like, I won't file like, there's more charges, and I won't file them unless like if you take the shit down that you said about like what? No, go fuck yourself. Go fuck yourself. Seriously, like what is that shit? Like this is you're gonna tell that to the guy right now who's already facing charges for the sake of fighting for free speech? You think that dude is just gonna fucking be like, okay, oh, he's gonna go fuck you. I've got a fucking Bradle, a Betero, I've got a fucking a Baden. Go fuck yourself. I mean, dude, that's insane, bro. Mateo, not fail, wins handle of the day, and it sketches.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. think we got a super chat.
How dare you?
What do you want, buddy? Hi. Mateo not fail. If LS was a member of your channel and she did some bullshit like this, would you put her on reprobation? That's an interesting question. Yeah. yeah. I mean, I would, I'd tell her to go fuck herself, most definitely, without a doubt. Like, I mean, listen, dude, like, I don't do that shit. I don't cater to the people who donate. You know what I'm saying? Like, I treat everyone the same, and I don't want, it's if she was acting like that and she was a member and she donated fucking Nan donations, dude, all the time, but did that kind of shit, I'd be like, yeah, you gotta go. You can't hang out here. You're not, you got no business here. You would have to just
Get the fuck out!
Not welcome. Not welcome.
Somebody get these beggars out of here.
All right, let's continue with British Grant. British Towel here.
Since April 2028, Kearney has extensively covered high-profile legal proceedings related to the January 29th, 2022 death of Boston police officer John O'Keefe and the murder accusation against his girlfriend, Karen Reed, who, after
Reed
sensational trials, was acquitted
What up, Danny?
of murdering O'Keefe. During Reed's Massachusetts criminal proceedings, LS, who subscribed to Kearney's content and apparently was obsessed with his coverage of the Reed case, deliberately sought out Kearney to act as a source so he would publish the details of her sickening abuse of Paul O'Keefe, the brother of John O'Keefe.
Yeah, that shit was fucked up.
LS catfished O'Keefe for the purpose of cataloging embarrassing and compromising information against him she has privately admitted and publicly denied.
It sounds like this poor dude is trying to do a Yoda impression, but isn't getting the mechanics of how Yoda really talks. You know what I'm saying? Just, it's like they're trying to talk like Yoda, but like they're just not getting it. Sparkly Rabbit just became a YouTube member. Welcome to Reprobates. Thank you so much.
That she gave this information to Kearney to publicly humiliate Paul O'Keefe and prevent him from being a witness at Red's 2025 trial, which is a clear violation of the Massachusetts
Red's
Witness Intimidation Statute, CMGLA 268, Section 18B. Eventually, the journalist source relationship between Kearney and LS broke down, after which L5 alleged Kearney cyber-harassed her. Ms. Haleko supervised this investigation, which lasted from November 2025 to July 2026. On July 7th, 2026, Ms. Haleko informed us that the ACPO was not prosecuting Kearney, only to call back within minutes and reverse course. Ms. Haleko presented the matter to the grand jury on July 22nd, 2026. Although the matter has since been assigned to Assistant Prosecutor Erin Rush on information and belief, Ms. Haleko remains involved in the matter in a supervisory and advisory capacity. Law Office of Mark Abedero, PC, William Reynolds, August 11th, 2026, page 3, the August 3rd, 2026 defense demand. On August 3rd, 2026, as required prior to making a motion for non-compliance with the state's discovery obligations, we sent Ms. Rush a formal demand in which we, A, outlined the ACPO's deficiencies in complying with its discovery obligations, and B, provided specific information to the ACPO so that your office was alerted to the existence of possible exculpatory evidence in your possession, custody, and control, requiring disclosure to the defense. Ms. Halayko was copied on the demand, not surprisingly in connection with her role as a supervising prosecutor, who conducted the lengthy investigation and grand jury presentation. Ms. Halayko is matter-of-factly mentioned several times in the demand letter in her professional capacity. See demand letter, August 3rd, 2026, page 2, describing Ms. Halayko as the lead investigator and grand jury prosecutor. Page 4, note 7, describing one of LS's lies to Ms. Halayko. Page 7, describing contradictions between LS's statement and statements Ms. Halayko made to counsel. At no point did our demand letter discuss Ms. Halayko or any member of the ACPO in their personal capacity. There is no mention of Ms. Halayko's or anyone else's home address, unpublished home telephone number, or any other private information. Clearly, on August 4th, 2026, Ms. Halayko knew that we did not mention her own or anyone else's personal identifying information in the demand letter, and that Kearney did not post anyone's home address or phone number or any personal information online. As the county prosecutor, we need not remind you that cases your office frequently handles result in press coverage and online commentary. The names of the prosecutors involved often are included in press releases, news articles, and internet posts. Kearney's case is a high-profile matter. As an independent journalist and staunch advocate for the First Amendment who regularly seeks to expose injustices and corruption, he regularly updates his followers on matters of public concern related to his own legal proceedings. This includes posting unsealed legal documents or communications that he believes are in the public interest. On August 3rd, 2026, without providing any editorial comment about the case, Ms. Halayko or anyone else from the ACPO, Kearney published the demand letter on his social media pages. 1 New Jersey Rule of Court 313-3C states that a motion for discovery shall not be made until the parties have met and conferred pursuant to Rule 39-1C, which states that the parties shall confer and attempt to resolve any discovery disputes before an initial case
we got time, bro. We got time.
Law Office of Mark A. Letterows, PC, William Reynolds, August 11th, 2026. Page 4, the August 4th, 2026.
We're only like halfway done.
On August 4th, 2026.
Oh, a telephone
approximately
call, huh?
10:35 a.m.
Hold on.
Ms. Halayko called Darren Gelber, who along with the undersigned and Linda Kenny Baden is co-counsel for Kearney in this matter. Ms. Halayko informed Mr. Gelber that Kearney was making online posts which named members of the ACPO and posting that information publicly. She specifically referenced the August 3rd, 2026 demand letter, noting that it contained names of prosecutors and others from the ACPO. At no time did Ms. Halayko allege that Kearney published any personal identifying information of herself or any other member of the ACPO. Ms. Haliko warned Mr. Gelber that Mr. Kearney should take down the posts which mentioned the names of the ACPO employees and remove them from the internet. When Mr. Gelber asked Ms. Haliko what was wrong with naming, public officials, Ms. Haliko ominously replied that there were laws in place protecting information about judges and prosecutors. Without naming it directly,
Okay.
Ms. Haliko apparently was referencing...
I don't think that that's true. Like, I don't believe that that's true, actually. Like, I think that, like, you can, like, they're public servants. You know what I mean? Like, they work for the public. So the public gets to know, you know, who these people are.
NJ5A 2C 2031.1, also known as Daniel's Law, which makes it an indictable offense for someone with purpose to harass or risk or expose a judge or prosecutor to...
The biggest fucking problem here isn't so much, this is what I was saying the last time, dude. Like, the biggest fucking problem here is that she's being enabled by a county prosecutor. You know what I'm saying? Like, this is wild. Like, why? Is the prosecutor looking? I mean, the only thing I can think of is the prosecutor's looking for headlines. That's the only thing I can think of. All I can think of is the prosecutor is just a fucking you know, an attention fiend. You know? I mean, that's all I can think of. All I can think of is because, I mean, everything that she's doing is wrong. And the fact that she's enabling this crazy person who's clearly crazy. Like, again, I said this last time. I could almost expect a crazy person that was doing that shit to Paul O'Keefe to walk into a police station and think that being called out for her shitty behavior is somehow a way to press charges because she was embarrassed because her own behavior was exposed. So I could almost expect somebody shitty enough to do what she did to walk into a police station thinking that she was done wrong legally. And so okay. And so when I think of a prosecutor like going, yeah, sure, let's move forward with this. Like, how is a jury gonna see the evidence against Stakuni and not think that she's a complete and total nut job? Like, I don't get like, I don't get what this prosecutor is getting out of this, because she's just going to look really, really stupid. And Letterows already calling out her unethical behavior. So
harm to life or property to intentionally or recklessly publish their home address and / or unlisted home telephone number. As noted, supra, neither the demand letter nor anything Kearney posted referenced Ms. Haliko or anyone else in any manner other than in their professional capacity as prosecutor or member of the ACPO, which is, of course, protected speech and appropriate information for the public to know. At the conclusion of the call,
Right.
Miss Haliko told Mr. Gelber that the ACPO was looking into the situation to determine whether they could take any action, but in the meantime, they wanted Kearney to take his posts down. Ms. Haliko's conflict of interest. Ms. Haliko's call to Mr. Gelber was inappropriate. It created an actual conflict that compels you to immediately remove her from any further participation. 2. In addition to Ms. Haliko, the August 3rd, 2026 is addressed to Ms. Rush, the assigned prosecutor, and briefly mentions ACPO Sergeant Vicky Levy, the sole witness who testified before the grand jury.
The detective.
This law was named after Daniel Salas, the son of...
Don't forget, Levy is the detective who worked on this investigation for 7 months. The 7-month long investigation into Aiden Carney, aka Dr. Turtleboy, aka Mr. Media. The 7-month long investigation into Aiden Carney writing a story about a crazy person for being a crazy person. This is just wild, bro. Like, and it's so dope. It's so dope. Like, think about it for a second. You got the Mighty One and Linda Kenny Bodden. Okay? Still worthy of the title Killer Bees. They're still Killer Bees, which is amazing. Linda Kenny Bodden, who defended Phil Spector. Okay? And technically, she beat Alan Jackson in court because he was the prosecutor. She won. Linda Kenny Bodden, my homie, my Wuthering Heights buddy, acting partner, is going to like wipe the floor with this prosecutor, bro. Like, give me a break. You know what I'm saying? Like, she beat Alan Jackson. And that's not to say she's a better lawyer than Alan Jackson. That's not even remotely what I'm even trying to imply at all. But I'm saying we know how badass Alan Jackson is. You know what I'm saying? We know how amazing of a litigator AJ, Alan Action Jackson is. See what I'm saying? Like, what do you think Linda Kenny Bodden is going to do with this case and this lawyer? Like, I want to go and sit in the courtroom, and it's bullshit that you're not allowed to eat popcorn in a courtroom. It's bullshit. If you could eat popcorn, I would fly there. If the judge was like, yeah, you can have popcorn for this, I would fly there. I would absolutely fly there for that, so that I could eat popcorn in the courtroom. An unprecedented. It would break me completely. It would break me completely. But it'd be worth it for the unprecedented time that we had popcorn during a trial. Because this shit is beautiful. Like, when you look at everything that's going on with this case, like, and then you think of, I mean, dude, I what comes to mind is like the dream team in the, what was it, the 92 Olympics? The dream team that just dominated the American Olympic basketball team They just dominated like it was crazy. It was almost globetrotterish. Like, that's how I picture this going down. Because there's no case here. There's no case. This is the anti-prosecutable case. That's what it is. It's like reverse. It's like reverse prosecutor. It's like reverse prosecutable. It's bizarre. There's no evidence that dictates that Aiden Carney did anything wrong. Yet all the evidence in the world spells out how insane Stakuni is. And I can't wait for it. Can't wait for it. It's going to be fan-fucking-tastic.
U.S. District Judge Esther Salas, who was shot and killed at Judge Salas's home by a deranged litigant who previously appeared before Judge Salas.
Wow.
Law Office of Mark Abedero, P.C. William Reynolds, August 11th, 2026. Page 5 in this matter. Ms. Haleko expressed her personal concern about being subjected to online criticism regarding her professional conduct resulting from nothing more than Kearney, who won as a journalist and defendant, lawfully posting a legal document on a high-profile matter of public interest without any reference or comment about Ms. Haleko. No public official wants to be publicly criticized for their professional actions, but whether Ms. Haleko felt she was unfairly criticized or just concerned about the public learning about her role in Kearney's case, her subjective feelings are meaningless weighed against Kearney's fundamental right under the First Amendment right.
Under the First Amendment right. Bro, my ass would fucking stop at Mickey D's before even going into the courthouse, bro. Fucking.
You don't come to my franchise, ask for a water cup, and then get a Coke. That's fucked up. You're fucking with the family business now, homeboy. Get the fuck out.
To publish information on a matter of public concern and to express his opinion that he is being unfairly prosecuted by the ACPO. Constitutional concerns aside, a conflict exists where a prosecutor allows personal interest to influence the exercise of state power.
Personal influence.
CRPC 1.7A2. This is exactly what happened here. Ms. Haleko clearly implied that because she was upset, Kearney posted her name and the names of other ACPO members online. Her office was investigating him for committing possible crimes by mentioning that she was looking into what professional actions the ACPO could take against Kearney for, naming her and others, and then stating near the end of her call with Mr. Gelber that, in the meantime, Kearney should take down the information that he had posted. Ms. Haleko obviously was implying that the only thing that would stop the ACPO investigation was Kearney bending knee to Ms. Haleko's threat and removing any reference to names of ACPO members, including her. What makes Ms. Haleko's conduct even more troubling is the fact that she knew or should have known that her threat to utilize Daniel's law as a cudgel to silence Kearney was in bad faith. It strains credulity that after reading a demand letter which briefly referenced her her involvement in a public prosecution, Ms. Haleko seriously believed there was a reasonable basis to investigate Kearney for violating a...
I was just saying that was a... Sorry, I was muted. That was a badass shout out to Melanie Little right there. That was awesome.
4. If Ms. Haleko's concern and threat were deemed proper, our criminal justice system would afford prosecutors to use intimidation to threaten people from exercising their right to free speech.
Exactly.
It would lead to a dystopian system where public servants armed with the ability to prosecute people who eriticize could operate in the shadows without accountability to the public they serve. That is un-American and would make a mockery of the First Amendment. For example, Ms. Haleko's reasoning, Kearney may have violated Ms. Rush's right to privacy and committed a crime merely by publishing a letter that was addressed to her. We struggle to see any purpose in Ms. Haleko's August call to Mr. Gelber other than to use her professional power to pressure Kearney into removing content which personally upsets her and / or other members of the ACPO Law Office of Mark A. Letterows, PC, William Reynolds, August 11th, 2026, page 6. Statute which prohibits publication of prosecutor's home address and / or private telephone number. But she did exactly that, and then implied that the only way for Kearney to avoid such an investigation was to satisfy her own and others' personal interest in having harmless references to her removed from the internet. An ACPO investigation of
harmless
Kearney under 2C:20-31.1 would be frivolous, abuse of power and
an abuse of power
of public
and
resources.
A waste of public resources.
When such investigation is threatened by a prosecutor in furtherance of personal interests, it is also a conflict of interest. Ms. Haleko's conduct may even constitute criminal coercion. NJS A2C 18-5 states in relevant part that a person is
criminal
collusion if
coercion
unlawfully to restrict another's freedom of action to engage or refrain from engaging. In conduct, he threatens to accuse anyone of an offense or takes or withholds action as an official or causes an official to take or withhold action. Here, Ms. Haleko knew, or should have known, that her threat to investigate Kearney under Daniel's law had no basis in fact or law. Clearly, her purpose in telling Mr. Gelber about a potential new investigation of Kearney while repeatedly expressing her preference that Kearney take down his posts was to restrict Kearney's freedom of action, that is, to suppress his right to post on matters of public concern. Nor should the irony of Ms. Haleko's attempt to stifle Kearney's speech and its adverse impact on the public's confidence in the criminal justice system be lost on you. Whether styled as a threat, warning, or simple request, Ms. Haleko's August 4th call to Mr. Gelber was nothing more than an attempt to institute prior restraint on Kearney's First Amendment right to speak on a matter of public concern.
Right.
No. Prosecutor should seek to close the marketplace of ideas by threatening criminal charges because she is upset about discussion of professional actions made in the course of their duties as a public servant.
Exactly.
Finally, irrespective of your view on the above, LS's repeated false statements will likely lead the defense to call Ms. Haleko as a defense witness at trial. Ms. Haleko's testimony will flatly contradict LS on numerous material topics, including LS's lies about the nature of the ACPO investigation, L5's ownership of social, media accounts, and LS's alleged fear of Kearney. See demand letter, August 3rd, 2026, pages 2 to 4, 7 to 8. In these circumstances, we urge you to voluntarily remove Ms. Haleko from this matter so that we may avoid addressing this issue in a motion, which will require Law Office of Mark A. Letterows, P.C. William Reynolds, August 11th, 2026, page 7. Substantial time and resources, sworn certifications from Miss Haleko and Mr. Gelber. An evidentiary hearing would require sworn testimony from them as well. The conflict created by Miss Haleko also warrants the removal of the ACPO from Kearney's case. In essence, Ms. Haleko, who authorized the existing dubious charges against Kearney, now alleges that she and others from the ACPO are victims of Kearney's improper conduct, which she has represented the ACPO is looking into.
Wow.
Clearly, if Ms. Haleko, Ms. Rush, and Sergeant Levy are potential victims, the ACPO should not be investigating any matters involving Kearney in which they are deeply involved. In these circumstances, it is in the best interest of the state that the ACPO step aside due to this conflict. See Uric versus State, 184N_J.70, 79 to 80, 2005. Attorney General may supersede county prosecutor if in best interests of state.
Yeah, that'll be great.
State versus Harvey, 176 NJ, 522, 525, 2008. Appropriate for Attorney General to supersede county prosecutor to avoid any appearance of impropriety. It is our hope that we can resolve this issue well in advance of Kearney's. September 23rd, 2026, arraignment in the Atlantic County Superior Court. Please advise us as soon as is practicable about your position on this matter so we can plan. Accordingly, in the event Ms. Haleko and the ACPO do not withdraw from this matter, very truly yours, /8/Mark A. Letterows, Mark A. Letterows. C.C. Erica Haleko, Erin Rush, Linda Kenny Baden, Darren Gelber, Aiden Carney.
Aiden Carney. Like, this fucking AI thing changed up like 10 times the way it pronounces words. Very weird. Very weird. But AI's like that, man. Well done, Grant. Thank you so much, buddy. My man Grande. So there's some other stuff going on. I hadn't watched this yet. Now, again, I shouldn't have exited out of here. Well, whatever. Oh, hell yeah. So, man, listen, bro. There's some drama going on in the old drama community right now. And it's pretty funny. Like, yeah, so some shit going on with Toasty and Queen Bee. I mean, I'm just gonna side with Toasty out of default. I don't even really know what's going on. Like, I'm just gonna side with Toasty out of default. Just like, if anybody knows how far back I go with that bullshit, you'll understand why. I'm totally Team Toasty, bro. 100%. Anyway, yeah, so there's some other shit going on that now I'm gonna play this video because the title really got me. And I will speed up, even though Brother Counsel does talk pretty fast. But stop what you're doing right now. Stop what you're doing right now. And go give Brother Counsel a like and make sure to subscribe to him if you're not subscribed already. Okay? I'm going to keep dropping it as the video plays, but I'm going to have him, good old BC Esquire, explain to us what's going on with this shit. Because apparently the title here is Karen Read full phone extraction in the hands of Jennifer McCabe. Trial lawyer breaks it down. So I'm interested in this, and I'd like to know what old BC says about it. So let me speed it up. I'm not going to speed it up too much because he already speaks pretty fast.
Because of the type of case we're dealing with, I think they should have preemptively filed this motion for protective order. Brought my equipment with me. I packed it all up. And then this morning, I see that something hits the docket in Karen Read's defamation case. So I've got to cover it, even though I don't have my fancy microphone and my fancy webcam. So hopefully you can all hear me all well, hear me all right, hear me well. Hopefully you can see me, and we will get right into this motion in a moment. Now, we are talking about the defamation case. So remember, there's the wrongful death case, which is filed by the O'Keefe family against Karen Read. And then you also have the defamation case, which is filed by the House defendants, Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins, against Karen Read and Turtlewood. Now, that defamation case, as we know, there's also just recently filed a notice of appeal, which I told you is going to happen on the anti-SLAPP issue. So even though that motion to dismiss based on anti-SLAPP, both by Turtleboy and by Karen Read, were denied by the judge, it is going to get appealed exactly as I said, and now everything's going to be stayed. But in the meantime, there still is this motion that hits the docket regarding a subpoena that was sent to the NDAO, the Norfolk District Attorney's Office.
Okay.
Now, what happened? Very simple. Both sides served a subpoena. Okay, so Karen Read's team, they've served a subpoena on the NDAO, seeking for all the discovery that they turned over in the criminal case. They wanted in the civil case as well. And then you also have the House defendants, in this case the plaintiffs, also their attorneys served a subpoena on the NDAO. Now, the way it works is that any time you serve a subpoena on a third party, you have to give notice to the parties.
Okay.
So the subpoena is not on Karen Read. She doesn't control the NDAO, but still they have to notify, as part of the notice requirements, they have to notify Karen Read's team that, hey, by the way, we are serving this subpoena on this third party. And guess what? If you have any issue with it, if you think that this is going to adversely affect your client, what should you do if you're an attorney representing Karen Read? Well, then what you should do is you should file a motion for protective order, or you file an objection to the subpoena. Whatever you need to do to get the issue in front of the court if you're nervous that your client's interest may be affected by that subpoena. And that's actually what happened when Karen Read served a subpoena. Her team served a subpoena on the NDAO. The House defendants filed a motion for protective order with respect to that subpoena. Now, what happened with Karen Read's team was actually a little bit different. And that may bring you to the first question of, well, why didn't Karen Read do the same thing as the House defendants? And that's a fair question. But we're going to see why in the papers. Still, I think if you really want to be careful, especially because you're dealing with the Karen Read case, you should do everything by the book and not always just try to work things out besides not filing motions. So because of the type of case we're dealing with, I think they should have preemptively filed this motion for protective order, but they waited. And because they waited, because they're trying to perhaps work things out with the other side or with the NDAO, without filing a motion for protective order, they kind of got messed up in this situation. So that's what happened. What happened was the NDAO actually eventually gave over the entire phone extraction. Karen Read's entire phone extraction is now in the hands of Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins. And I can assure you that they are combing through that entire extraction of hers at this point. And Karen Read's team is asking them to delete them.
That's not good at all.
Delete the extraction, which they don't want to do, as you can imagine. So this is the trouble that they found themselves in. And I think part of it is because they didn't right away, as soon as they received that subpoena, file a motion for protective order immediately, as soon as they can. So this doesn't happen. But anyway, let's go through what happened here. So first, This is the motion. And unfortunately, again, they've got Barnstable mentioned here instead of Plymouth. You got to get the caption right, guys. Come on. This is look.
So this is interesting because I wonder, obviously I have trouble with these horrible people having access to all of Karen Reed's phone extraction. This is quite troubling, to say the least. It's quite troubling, but it's going to be interesting to find out if anything is going to be used from that, or if it can be used from that against Turtle Boy in his case, involving his charges. Now, I would be willing to bet that if they can use anything, they will. If they can. If there's anything that they can use, they will. But if they don't, I don't think that, I think we can shut this whole stupid door on whether or not Karen Reed and Turtle Boy colluded to harass and intimidate witnesses, which is a big pile of dog shit that even Cryford wouldn't pick up. I mean, it's a pile of dog shit. It's worthless. Because the fact of the matter is Aiden didn't harass or intimidate anyone. He exercised his free speech, and he created awareness and built support. Because here's the thing. This is what you can't deny. Okay? I hope that's thunder. Okay, yeah, it is. So here's what you can't deny is that it was the Commonwealth of Massachusetts that was prosecuting Karen Reed. Right? That means that it's the people. Because in many courtrooms in many states, they say the people versus Karen Reed, right? But here they say the Commonwealth versus Karen Reed, meaning the people of the Commonwealth, the people of Massachusetts. So, all Aiden did was make sure that the people of Massachusetts, who these prosecutors, who the Norfolk County District Attorney's Office was representing, was speaking for. He wanted to make sure that those very people saw and understood all of the facts of the case. And so they did. And those people, seeing the facts of the case, decided to support an innocent woman because the facts dictated that she was innocent. There is no alternate reality where this is somehow wrong. I mean, not in the United States of America. I mean, that's the kind of shit that happens in China. You know what I'm saying? Like, that's not, we don't do that shit here. If we represent the people, then you represent the people, and the people have a right to know what's going on. And Turtle Boy provided the people with that information, which created a movement. And it created a support system for an innocent woman who is being wrongfully prosecuted. That is not unethical. That's not illegal. That is exactly what the foundation of this country was built off of. This is the idea. To make sure the power is in the hands of the people. That's all he did. Okay, well, if you're going to represent the people deserve to know. That's all he did. And then he got prosecuted. Then he got framed again to have his bail revoked, and he did 60 days in jail.
What could be more egregious? What could be more misleading than that? And what could be more important?
Exactly.
A little bit sloppy. So you got Barnstable instead of Plymouth, and this is Karen Reed's memorandum of law in support of the motion for protective order. The plaintiffs in this case have refused to delete copies of a full extraction of defendant Karen Reed's cell phone, which were mistakenly produced to them by the Norfolk District Attorney's Office. Plaintiffs insist on retaining these full extractions despite the fact that such extractions contain years of irrelevant, private, and protected information. They have the full extraction of Karen Reed's phone. This is the same extraction that the plaintiffs in the wrongful death case pending against Reed agreed to delete, subject to Reed's representation that she would review such data and produce it in line with her discovery responses. So what happened in the wrongful death case is that in that case, what happened they agreed upon is that Karen Reed would receive her extraction and she would review her extraction, and then she would determine what is relevant to the production or the request for production. Not give the other side the entire extraction and ask them to delete the irrelevant parts. And by the way, this same process of allowing the person himself to go through his phone extraction or her phone extraction to determine what's relevant, that's exactly what's happening with Colin Albert. Colin Albert and his attorney are able to look through his extraction and decide what's relevant. So Karen Reed, that's what she's doing in the wrongful death case. She wants to do that in the defamation case, but it's a little bit too late at this point. But now they're asking for the other side to delete it. Reed asked this court to impose the same protection and requirement in this case. Defendant Karen Reed seeks an order requiring plaintiffs and their counsel to delete all copies of the full extraction of all data from Reed's cell phone seized by the Massachusetts State Police on January 29, 2022. These extractions contain all data from Reed's phone other than, according to the Norfolk District Attorney's Office, limited attorney-client communications. So the only thing that they purged or redacted was attorney-client communications. But everything else is in there, which the NDAO has indicated were removed by a so-called taint team from the Massachusetts Attorney General's office. That means the extractions contain a full and complete record of Reed's activity on her phone from years before January 28th, 2022, including obviously irrelevant, confidential, and private data and communications, such as medical documents and information, financial account information, geolocational data, personal correspondence unrelated to Mr. O'Keefe, and other private matters. In the wrongful death case between Reed and the estate of John O'Keefe III, after the plaintiffs in that case served a subpoena on the NDAO demanding any such extractions, the wrongful death plaintiffs and Reed agreed that the NDAO would produce this data to Reed's counsel, and the Reed's counsel would then review it along with other sources of potentially responsive documents and produce it consistent with Reed's responses to the wrongful death plaintiff's request for production. Then, when the NDAO produced the extractions of the wrongful death plaintiffs notwithstanding the prior agreement, Reed's counsel notified the wrongful death plaintiff's counsel who eventually agreed to delete the produced copies of this full extraction. So what happened in that case is they actually had an agreement. They had an agreement with the wrongful death plaintiffs, with the O'Keefe family, and with Dillard. And even though they had the agreement with the NDAO still messed up and produced a full extraction. But at that point, it's much more difficult for Dillard to say, I'm not going to delete it, if you already had this agreement in place. So Dillard did eventually agree to delete the produced copies of the full extraction. In this case, however, the plaintiffs have refused to agree to the same deal. On or around May 6, 2026, the plaintiffs served a subpoena on the NDAO seeking all documents the NDAO had produced in the wrongful death case. In response, the NDAO indicated that it would provide certain documents to plaintiffs, but would wait to provide extractions that were the subject of the earlier agreement between Reed and the wrongful death plaintiffs to give Reed and the plaintiffs in this case, time to discuss a similar arrangement. So what the NDAO did is they received a subpoena by the House defendants, the plaintiffs in this case, and they said, okay, we'll produce certain documents, but in terms of Karen Reed's phone extraction, we're going to wait and see if you guys can figure out an agreement between the two of you. If you guys can figure out an agreement similar to the wrongful death case, then great, we will do exactly what we did in that case. Well, not what they did in that case, but what they should have done in that case, and only produce whatever documents Karen Reed said is relevant. Now, in this case, the NDAO said that they're going to do the same thing. However, before counsel reached any such agreement, the NDAO produced multiple copies of the full extraction of Reed's phone to plaintiffs. So now I don't know what happened in between. It could be that they did not reach the same type of agreement. I don't know if there's any communications between the two of them trying to reach an agreement, but what most likely happened is that the House defendants lawyers, Tuxbury and our favorite associate Karen Murphy, they probably spoke to the NDAO and said, hey, we don't have an agreement. You've got a valid subpoena. You've got to follow the subpoena. and give us all that data, including the phone extraction, the full phone extraction. Because there's no motion to protect the board that was filed. There's no objection that was filed. We don't have any agreement. Maybe there's even, I don't even know what communications there are, but most likely I would have guessed that the Tewksbury and Karen Murphy said to the NDAO, turn them over. And they did. They listened. After confirming with the NDAO what had been produced to plaintiffs, Reed's counsel immediately informed plaintiffs' counsel of the issue and the prior agreement with the wrongful death plaintiffs and requested that plaintiffs' counsel delete any copies of the full extraction.
So is the phone extraction sealed? Like, can they do anything with it? If the House defendants have the phone extraction, then what can they do with it? Is what I'm curious about.
They had received. Reed proposed doing the exact same thing she did in the wrongful death case. Review the data from these extractions along with other sources of potentially responsive material and produce documents as indicated in a responses to discovery requests. Plaintiffs' counsel refused this same protocol and refused even to confirm that they would not review or use such data prior to the court resolving a motion on the issue. And the unfortunate part for Karen Reed is that it seems that the defendants, in this case, the House defendants, not the plaintiffs, Jennifer McCabe, etc., they could posture this way. They could say, hey, we never had an agreement. And therefore, no, I'm not going to delete it. We served the subpoena. You never objected. You never filed a motion for protective order. We didn't have an agreement. So no, why should I just delete the information that I got in a valid subpoena? So that's how they're posturing. And that's what you have to expect in this type of case. Okay, if you're Karen Reed's counsel, you've got to expect these type of things and therefore be preemptive. File the motion for protective order. Don't assume everything's going to be working itself out, especially when you got a million things going on in all these different cases. Now look at footnote number 3. According to the NDAO, it was unaware until conversations with Reed's counsel after this production in this case that it misunderstood the scope of the earlier agreement between Reed and the wrongful death plaintiffs. Reed does not seek any relief against the NDAO on this issue at this time. So now some people may say, hey, this was not any sort of mistake here, but that's aside from the issue here. Here, the question here is, what happened up until this point? At the end of the day, the NDAO had a subpoena. There was no objection. There was no protective order. There was no agreement. And we don't even know what type of communications there were as part of the agreement. I would assume that if there's some sort of communications back and forth about trying to reach an agreement, they would attach it to this motion. So if Karen Reed's team had these type of communications, okay, what's the agreement going to be? Can we do it this way? Can we do it that way? Let's get back. Let's confer. Let's do a 9C, whatever they want to talk about, whatever they want to call it. But if that was done, you would think that this would be attached as part of their motion, showing that there's been communications, we're close to an agreement, and then all of a sudden they get this full extraction. So then that would make their position a lot more reasonable. But if there was like one email sent 3 months ago saying, hey, guys, what are we going to do about this? And no follow-up, no nothing.
It's like, let's just be real, Jody. You're saying you would think the DA's office would know better than releasing Karen Reed's entire phone extraction. Tully did the same to Lindsay Gatuni. Unbelievable. You think this is an accident? You think that the Norfolk County DA's office accidentally just let them have Karen Reed's phone extraction? Like, oops. No, dude. Come on, bro. These people got an axe to grind. Come on, dude. Karen Reed embarrassed them in front of the world. Let's get real.
They're not going to be looking that great. But anyway, let's move on. The extraction in question contains what appears to be an entire image of Reed's cell phone, including all communications, files, browser information, and history and other data. The NDAO has explained that the extraction should not include direct attorney-client communications, but that nothing else would have been removed by the taint team that the NDAO says reviewed the material. Plenty of the data that is relevant to this case has already been produced and will be produced in the future, including Reed's call log, search history, text messages, locational data, and other communications from the relevant time period. However, the copies the NDAO produced containing everything without regard to time period or relevance that was produced. Of course, plaintiffs are entitled to discovery in this case if Reed's pending anti-slap motion is denied. So this is already filed before. And by the way, the appeal is heard and denied, then discovery will open. So of course, they're basically saying we will produce discovery, we produce whatever you want, whatever is relevant, but you still should delete all the irrelevant information. However, they are not entitled to years of indisputably unrelated and irrelevant data, some of which is highly personal, protected by applicable rules and laws. That is why Reed proposed to plaintiffs the same thing she agreed to with the
Yeah, real quick. How much did Emily C's fundraiser for Adam Deitch raise? Because, big shout out to Emily C for that, man. That was awesome. She had David Yannetti on there. That was just really great that she had so many people up there. Kick ass. Does anybody know the amount that was raised? Over 10K. Ruby C says. Okay. Yeah, right on. That's fucking awesome. That's fucking awesome. Fucking Emily C, dude. Always kicking ass. Right on.
For the plaintiffs, these plaintiffs have rejected that proposal. So they said, no, we're rejecting that proposal because you know what? We have a valid subpoena and you didn't object. And now you're too late. Sorry. That's basically what they're doing. And that's what you can expect in this type of case. All right. Therefore, we respectfully request that the court allow the motion and order plaintiffs to delete all copies of the full extraction of Reed's phone produced by the NDAO. Okay. So that's essentially what their motion is. And let's see what the House defendant's response is. Now, first of all, they do have the right county here, Plymouth. So good for them. But let's see what their opposition is. Plaintiffs Jennifer McCabe, Brian Albert, etc., respectfully oppose defendant Karen Reed's motion for protective order requiring plaintiffs to delete the data incorrectly produced by the Norfolk District Attorney's Office. First, the motion is procedurally improper. Discovery in this case was automatically stayed on July 7, 2026, following Reed's filing of a motion to dismiss under the Massachusetts anti-SLAPP statute. So remember, once you file a motion to dismiss based on anti-SLAPP, everything gets stayed. Discovery gets stayed. You cannot do discovery. So their first argument, which is a loser, by the way, is going to be, well, you can't file this type of motion because it's discovery related and all discovery is stayed. That's not going to win. That's not the winning argument, and I don't know why they start off that argument. Usually, you want to start off with a strong argument. This is not a strong argument. The relief Reed seeks is essentially an order compelling plaintiffs to delete certain data obtained through a subpoena issued during discovery. That is a discovery-related order, and the court cannot adjudicate such relief while the statutory stay is in effect. Second, the data at issue was lawfully obtained by plaintiffs pursuant to a validly issued subpoena served on the Norfolk District Attorney's Office. Reed failed to object or to move to quash that subpoena before production occurred and has not cited any authority justifying her request to claw back materials that were obtained through an otherwise valid subpoena. Moreover, contrary to the implication made in Reed's motion, plaintiffs are under no obligation to honor the terms of a private agreement between Reed and the plaintiffs in an entirely separate case. Let's keep that in mind. The O'Keefe family is separate plaintiffs. They're not the same as the House defendants.
Right.
They're represented by different counsel.
Right.
There's very, very likely communication.
They're the plaintiffs in another case.
Very closely together, if I had to imagine. So therefore, Diller very may well have the full extraction right now, or he's able to look at it. But the point is that technically it's separate cases.
Right.
So just because you have an agreement with Diller on the wrongful death case does not mean that we have to agree to that same agreement.
Right.
And that's a good point. That's a stronger argument than the first argument. Finally, the relief sought is fundamentally inequitable. Reed currently possesses a full phone extraction belonging to plaintiff Jennifer McCabe, an extraction McCabe voluntarily provided upon request of the NDO exclusively for use in the criminal case against Reed. Reed, however, intends to use McCabe's phone extraction, which contains years of information and data prior to January 29, 2022, in her pending civil litigations. So now they're saying, hey, what's good for the goose is good for the gander. You can't have Jennifer McCabe's entire phone extraction and then complain to the court that they shouldn't have your entire full extraction. Now, whether that's true or not, we don't know. I mean, I don't know if they have Jennifer McCabe's full phone extraction. That's just questionable. In other words, Reed demands that plaintiff delete her own phone data, but has refused to delete the identical category of data she holds belonging to McCabe. Reed's hypocrisy constitutes inequitable conduct warranting denial of the motion, or in the alternative, in order that Reed also delete McCabe's phone extraction. So they say, okay, look, you want to do it your way, fine. Then you got to delete Jennifer McCabe's phone extraction. So first, the argument about the special motion to dismiss that discovery is stayed. That's not going to win here because this is not like discovery. What you're talking about discovery is you're talking about depositions, interrogatories, request for production, subpoenas sent out. This is a motion. This is a motion for protective order. It doesn't really fall in the category of discovery. The whole point of pausing discovery is so that you don't have to go through all the costs of discovery when you have an anti-SLAPP issue that has not been resolved yet, because you could be that's the whole point of anti-SLAPP, to protect litigants against very costly discovery and attorney time. So this is definitely not does not fall within that protection. So that's not really good.
I mean, what could fucking be on there? You know what I'm saying? Like, I'm of the opinion that there's nothing on there case related that is bad. I think what Karen Reed is worried about is the phone extraction being entered into being submitted and then it becoming public. I think that's what she's worried about. I don't think that she's worried about anything incriminating in there. I think she's worried about personal things that shouldn't be anyone's business and being blasted out there for the whole world. I think that's what she's more worried about. I mean, what else would an innocent woman be worried about?
So we'll move on to the next one. Lawfully obtained. It is undisputed that plaintiffs obtained the phone extraction at issue through a subpoena served on NDAO on or about May 6th. Prior to service of that subpoena, plaintiffs provided notice to Reed pursuant to Rule 45. So as we said, you have to let the other side know whenever you're serving a subpoena. If you're serving a subpoena on a third party, you as an attorney on the case are going to get notice of that, and then you can do whatever you want. You can file a motion, or you can say, hey, I don't care if you get that information. So they did serve it on Karen Reed's team as soon as they served that subpoena on NDAO. Further, that subpoena was validly issued pursuant to Master Rule Civil Procedure 45 and directed the NDO to produce documents previously produced in the wrongful death case. The NDO complied with the subpoena and produced the requested materials to plaintiffs on June 1st, 2026. There is no allegation that the subpoena was defective, improperly served, or otherwise legally infirm. Reed also does not dispute that she was aware of the subpoena before the NDO produced the materials. Despite this awareness, Reed did not file a motion to quash and did not seek a protective order prior to production. Under Massachusetts Rule Civil Procedure 45, a party affected by a subpoena must act with reasonable promptness to challenge it. Reed failed to do so and instead seeks post hoc relief, meaning after the fact, regarding a subpoena that was issued over 2 months ago and a production that was transmitted over 1 month ago. The instant motion runs afoul of Rule 45's reasonable promptness requirement warranted denial. So they're saying, well, it's not, you didn't file it fast enough. Additionally, Reed's argument that plaintiffs should be compelled to follow the same protocol agreed upon by the plaintiffs in the wrongful death action is misguided. Plaintiffs in this case are not parties to the wrongful death case and were never part of any negotiation process or agreement reached in that separate proceeding. But simply, the agreement between Reed and plaintiffs in the wrongful death case was a voluntary private arrangement between different parties in a different case. Reed cannot unilaterally impose the terms of a separate agreement upon litigants who are not parties to that agreement and who owe her no contractual fiduciary duty with respect to its terms. This is particularly true, whereas here, plaintiffs in this case are not similar situated to the plaintiffs in the wrongful death case, since Reed refuses to destroy the full phone extraction of plaintiff Jennifer McCabe, etc. Of course, a voluntary courtesy extended by one litigant in one case does not ripen into a judicially enforceable obligation on an entirely different set of parties in a separate action. Reed identifies no rule of civil procedure, statute, or binding precedent that would compel the relief she receives. And then the next argument is that, well, Jennifer McCabe should not have to.
Well, yeah, that's a separate issue, James Lynch. The extraction is different than her phones itself, than the phones themselves. So they still have her phones, which makes no sense. Again, I think that's just pure fucking spite. Bullshit. Another pile of dog shit that they have her phones. But this is the phone extraction. The phone extractions took place. The phone extraction took place. And so this was subpoenaed by the House defendants, their attorneys. So since the House defendants subpoenaed the records, then, you know, okay. So at least I think that's what happened. If I'm understanding this correctly, I could be wrong.
Turnover. Oh, you know, Karen Reed should not be able to have. Well, it's not fair. It's inequitable for Karen Reed to have Jennifer McCabe's full extraction, and for her not to have the other side not to have Karen Reed's full extraction. So here's the thing. Again, I think, and it sounded like from Karen Reed's motion. Now, just take another look at it quickly. I thought that they were trying to make the case here that there was some discussion between Karen Reed's counsel and the counsel for the House defendants about coming to some sort of agreement. It does not seem that way. It does not seem that way because I would think that there'd be some sort of reference to those emails. So I don't know if there's any sort of agreement that was discussed with the House defendants. And if there's no agreement in the emails, there's no attempt to have an agreement, there's no objection that was filed, there's no motion for protective order, there's no motion to quash, well, then Karen Reed's side is not going to be so strong. Now, there still is a fundamental protection or privacy issue here, which even though you're late, the judge may step in and say, okay, well, you know, you guys didn't exactly follow this the right rule.
Yeah,
right way.
like
now you are.
Like, yeah, she's trying to get the judge. So Karen Reed's trying to get the judge to make them delete everything off of the phone. And trying to like pretty much just like, suppress the phone extraction, to not be able to use it. But the thing is, I mean, they already got it. And the judge is saying, well, you guys have to work that out between the two of you. You know, I'm not going to make an order on that. You guys are going to have to figure this out. So I don't know what's going to happen here. Because brother counsel seems to be thinking, well, you know, Karen Reed's case for this, Karen Reed's argument isn't so strong.
Filing this motion for protective order, okay, now we decide that it's, you know, it's unfair, or we have to protect her privacy, or maybe he'll say, okay, I don't know what's going on with Jennifer McCabe's extraction. Let's see how much years they have from her phone extraction. I don't know. But the point is that the judge may still grant the motion for protective order. But that does not mean at this point that they're not combing through her communications. They're going to have them, and they're reading all of her communications.
Right. That's exactly what's happening right now. Like, none of that matters in terms of her privacy not being violated in the meantime, because they have it. They have her shit. They have all of her phone extraction right now. You don't think that they're going through it? You don't think that they're fucking going? I mean, you don't think that right now, Jen McCabe, Carrie Roberts, Brian Albert, you don't think that they're all just sitting around fucking going through every single text, every email, every fucking thing that's on Karen Reed's phone? Every fucking video, every picture, everything.
Now, I think also, and there's a reply here, but whatever, you guys kind of get the point. I think that also there could have been an argument in this specific motion about the fact that Colin Albert, in this case, the judge said to follow the procedure that we are asking for to follow in with Karen Reed. That's what they could have also made an argument for. Same way you're doing with Colin Albert. You're not giving us the extraction, asking us to go through it. He's able to parse through it. So then we should also be able to parse through it. It should be fair in the same exact case, in the defamation case. So meaning, even though it's the same judge in the wrongful death and the defamation case, but still, you want to really say, okay, they're separate cases, but at least in this case, it should be the same way that it works with Colin Albert. It should work with Karen Reed. But I got to say, I mean, this is just, again, not a great look for Karen Reed's attorneys here because, you come here for objective analysis. They should have been a little bit more proactive in this case. I think they should have been more preemptive and filed their appropriate motions or objections so that they don't get to this. But now, I'm sure they're very uncomfortable with Jennifer McCabe and all that side, Colin Albert, Brian Albert, looking through all of our communications. And if they get to keep them, and let's say they find something and they bring it to the attention of the judge, say, hey, okay, but we still found something which is relevant to what we think is relevant. And even though if we're going to have to turn it over, but if she says anything different, then this is not a good situation exactly if you are Karen Reed. So, but that's why you come here. We got to be honest and we got to be objective. So we'll see what happens. The judge still, like I said, may agree with Karen Reed's team. He may still say, okay, this is how it's not going to work like this just because I got you. I got you moment. We are still going to protect Karen Reed's privacy. So at this point, you do have to delete it. But right now, they can be looking through that entire extraction. So that's going to be it for today. I hope you're able to hear me okay. And we're going to be hitting the road in a couple minutes, and you'll be seeing a different background as wherever I end up landing, and we'll be covering some whatever else happens to Karen Reed, Turtle Boy, and Lindsay Clancy, or any other cases that come up in the next couple of days. So that's going to be it. If you have yet, please hit the like, hit the subscribe. Usually we sound better. Usually we look better, better lighting and all that good stuff. So don't judge this brother counsel just from this video. All right. We will see you all later. Take care. Safe travels.
All right, brother counsel. Fantastic. All right. So, yeah, that's disturbing. So now the McAlberts have access to everything on Karen Reed's phone, which is a very, very disturbing thought, in my personal opinion. I mean, and I really don't think it's going to answer a lot of questions, I mean, the only question I can imagine, maybe it has, maybe we'll get an answer to.
Do the Martians have two sexes like we do?
I wonder if Karen's phone has the answer to that. I have no idea. All right, so let me see something here. Oh, okay. Hold on a second. All right. All right, I'm gonna take a couple of calls. See, I'm very surprised Karen Reed's attorneys made such a big mistake. Why would they like an order right? Why wouldn't they like? I don't get what that means. I mean, I don't care. That's what sucks. It's like, I feel like the thing is the way I look at that is we're talking about an innocent woman here. We're talking about a woman who went through 2 trials to prove her innocence. And now the very people who fucking framed her have her phone and have the contents of her phone. And they're just spiteful fucks. And you know they are. So you know what they're going to do with that shit, and who knows what they're going to do with it. And the fact that they have that access to her privacy, those people of all people, has got to really sting. That's got to really suck for Karen Reed. That's got to be something that really, really fucking bothers her. And I can't blame her at all. Out of all the people, these people have her just access to a lot of her privacy. Yeah, I just feel like she's been through enough, you know?
Call from.
You're on. Who am I speaking with?
Jeremy from Sacramento.
What's up, Jeremy from Sacramento?
Or I guess since Donald from Rochester gets that accent, maybe it should be, dude, it's Jeremy from Sacramento, California, man.
Oh, okay, dude.
This news pissed me off so much. It's like every time we turn around, it's like another, like, oops. Like, you know, they didn't accidentally release it. You know, they just dumped the whole thing.
Yeah.
They like to do that. Just like the same way Diller, like, blatantly just lies and said, oh, yeah, he just didn't show up. Like, and then later, like, well, actually, he did say that he wasn't going to be there. Like, what the fuck? Like, make up your mind, man.
I mean, I'm not even sure. I don't even know. Did they even file a subpoena to like get the phone extraction, or like how did that work? That's where I'm a little lost on it.
It's the most confusing part is that there's so many different cases, right? I could have swore that there was first it was that obviously the judge Bev had ordered to have her property released. Then it was what? There's been a couple of judges, but then they keep like saying, "Wait, hold on a second." And then apparently at some point they finally did say, "Okay, we're going to do a tank team and all this," but it's just another one of those. And the other counsel is like, "This doesn't look good." Like, oh man, if he says that, I just keep waiting for the. They did it on purpose, right?
Yeah. Hey, Jeremy, thanks for calling in. I'm gonna have to wrap this up.
Yep. Well, take care, buddy. No one was calling, so I'm like, all right, I'm gonna call.
Yeah.
I was waiting.
No, we got some breaking news here at the moment. So.
All right, buddy. Talk to you later. I'll be watching.
Thanks for calling, my man.
No problem. Bye.
Bye. So the Fall River Reporter just posted that Ken Mello has passed away. Ken Mello is now no longer with us. So a well-known attorney in the Fall River area and beyond has passed away, according to friends of the deceased. Ken Mello was a Massachusetts attorney based in Fall River who had practiced law for more than 4 decades. Mello operated the law office of Kenneth Mello on Dufree Street, focusing on criminal defense, personal injury, family law, workers' compensation, probate, municipal law, civil rights, business law, and labor law. In recent years, Mello gained wider public attention when he was appointed as a special prosecutor by the Norfolk County District Attorney's Office to handle certain witness intimidation cases against blogger Aiden Carney, known as Turtle Boy. These cases arose in connection with Carney's coverage of the Karen Reed murder case. Mello was later disqualified from at least one of the matters after a judge determined that his communications with a witness made him a potential witness himself. Some of the cases involving Carney have since been dropped or reassigned. In April 2026, Mello faced a criminal charge of threatening to commit a crime stemming from an alleged incident in Charlton Memorial Hospital in Fall River, which had since been dropped. This is about the coldest fucking okay, I don't know why I did that. I don't want to do all that. This is about the coldest fucking article about someone dying that I've ever fucking read, bro. Like, Fall River reporter does not like Ken Mello, bro. You can tell. And I mean, none of us did either. Let's not fucking be phony here. You know what I'm saying? Like, let's not be fake. Like, we have made significant fun of this man. I have myself, and I don't regret one fucking word of it. Everybody fucking dies, okay? It is unfortunate for his family, I guess. I don't know what kind of guy he was in his personal life. The fact of the matter is this guy prosecuted a case and weaponized an unconstitutional law to try to get someone locked up for exercising his First Amendment rights in order to intimidate him. This guy was the muscle behind the intimidation tactics by the McAlberts to have Turtle Boy charged and then have his bail revoked. This is not changed because Ken Mello is now dead. This is not changed. Okay? So I'm not going to sit here and pretend like I feel bad, because I don't. I don't wish death on anyone. But the fact of the matter is the only thing I know about this guy are the things that I just named. And that he had reprimands from the bar. This is a guy who treated his clients like shit when he was a defense attorney. So the only things that I know about Ken Mello are not flattering at all. And he faced criminal charges just recently. Now, I think those charges are a little bit much, if I'm being completely honest. Because the fact is I mean, I think he was just trying to like when he said, how about if I stab you a bunch of times? I think he was just trying to like illustrate the pain that he was feeling and them needing to move him and him expressing and illustrating in a very unnecessarily colorful way of the pain he was in and the pain that caused. I get that. But that's about as positive as I could say. That's about as positive of things that I can think of to say about Ken Mello, if I'm being completely honest. You know, rest in peace, I guess. But this was not someone who in his living years, from what I got to know of him, gained any of my respect at all whatsoever. I like Cosgrove more, but the problem is Cosgrove is still prosecuting this case, knowing exactly what's happening here. And I don't think he's into it. I don't think he likes doing it. at all. And he didn't write his website. Like he had three F's in office. I remember I went over this. I remember I did a stream, a couple of streams about Ken Mello. I went over those reprimands. I went over and I showed the the thing where it had the three F's. So yeah, Ken Mello is done. And I guess that's a shame. I don't know. You know, like, I'm not gonna lie though. Like, because I mean, Cosgrove, he's not exactly running sprints in those Velcro shoes. You know what I'm saying? I'm gonna be really sad. Like, there's something about Cosgrove I like. I can't really explain it, but I like Cosgrove. I think Cosgrove is a good guy, but I think that he sucks for doing what he's doing. Like, this is not okay. Like, he's trying to, like, take this person's freedom away. He's trying to take Aiden Carney, a.k.a. Dr. Turtleboy, a.k.a. Mr. Media, trying to take his freedom away. I don't like that. But stop it. Stop it. Yeah, I don't like it. Yeah, I'm going to be sad when Cosgrove passes on. I'm going to be really sad. But I think he's still got a few more good years in him. I think he'll make it through the trial. I think he'll make it through the trial. I think he'll live long enough to catch a proper spanking from the Killer Bees. But yeah, I think I'm gonna keep this one 2 hours tonight, folks. I know I was doing a call in, but yeah, I've had a really, really long day. I got let's see. Oh man, yeah. Honey Bear, member for 21 months. Thank you so much. And Stephanie Patterson, thank you so much. Here's the thing. It's a catch with the feels. Rest in peace for real. Pain and death is sad. However, I wish he could have stuck around for the equivalent of Aiden. I agree. Yeah, God, you guys can tell how tired I am. Look at this shit. Look at this is what I did today, bro. Look at this. Fucking look at that shit. 16,000 steps, 9 miles. That's fucking crazy. And I went to the gym. Yeah, I'm exhausted. And it like just hit me really hard. So yeah, I'm gonna wrap this up. I'm really tired. So lots of good energy to send over to Dr. Turtle Boy. I hope his ear gets better. And oh my God, okay. Wait 1 second, folks. Where is that? Oh, okay. Oh, there it is. Jody just sent me a $25 Venmo. That's really, really nice. Thanks, Will. You are appreciated. Thank you so much, Joey. God, I'm so tired. I can't believe I'm yawning on a live right now. I'm so fucking tired. Jesus, that shit hit me hard. Jimmy just texted me. Very, very funny text. Jimmy's texts are always really, really funny. But all right, folks, that's it for me. Guys, thank you so much. I really appreciate you guys hanging out. And I really appreciate you guys and all the support, man. You guys are so generous and kind, and it means the world to me. And remember, guys, it only takes a second to stay safe. Being retarded never stopped anybody from being a good neighbor unless you're a fucking McAlbert. Guys, I love you very much. And we will do this again very soon, my friends.
Watch out!
Today, being retarded means leading a full life. Retarded people go to work or school, just like their neighbors, and come back to a real home. A supervised home, right in the neighborhood, where they belong. Being retarded never stopped anyone from being a good neighbor.